Oh, yeah.
Look at there.
The agreement.
It's an agreement. Besides the agreement. All right, here we go. You guys ready? Look at this. A packed house. Make some changes in the forms that have to do with your money.
That's how you get
Look,
them to show
everybody
up.
shows up. All right, so you should have in front of you 4 different forms. Okay, the first one they may not be in order of how they're given to you, but the order we're gonna go in today is the first form, which is now called Form 120, Compensation Agreement, Listing Broker to Buyer's Broker. Then the second form, to keep it as clear as possible and not confusing at all, is also Form 120, Compensation Agreement, Seller to Buyer's Broker. So the 2 different names of the forms now are Form 120 LB to BB and Form 120 S to BB. So those are your very distinct different names of those forms. So you got those 2 first. Then you have Form 130, which is the exclusive right to buy buyer agency agreement. That is the third form we'll go through. And then the fourth and final one we'll talk about today is Form 310, our favorite one, the purchase and sale agreement. Okay, so I'm gonna go through the changes today. We're not gonna go through line by line each form. So I just wanna set that expectation because I wanna make sure we get everything covered. It's not a lot. And what I know happens is it brings a lot of questions, which then become a lot. And we will get through as many of them as possible. We've got till 5 o'clock tonight to go through this, so we'll get it done. Jokes don't change. All right, so what do you want to get out of today? Why are you here? Actually, let's start with this. Let's back up. Tell me something good. Give me some gratitudes. Kylie,
I'm getting ready to go on vacation.
she's getting ready to go on vacation. Where are you going?
Yeah.
Where are you going? You missed the point of the exercise. Tell me something good.
Good.
There you go.
That is all very good.
Okay,
I just
good.
really want to take a real vacation.
There you go.
We're going a bunch of places, Virginia Beach.
Nice.
Wood Forest, Pennsylvania, and West Virginia.
Love it. So a little bit north. That'll be helpful. What else? Tell me something else good. Yes,
Son recovered from his injury.
that's awesome. Very good. Thank you for sharing that. Yes,
My daughter ran for a regional office and won for an organization, a team leadership organization, spoke in front of 800 kids. It was a delegate vote. There were 33 delegates. She got 29.
that's awesome. There you go. Gee, I wonder where she got it from. All right, give me a couple more. 2 more.
I got a new car.
You got a new car. Woo-hoo. Love it. Love it. One more. Yes.
Moved to town, I'm new here, and I bought a really, really nasty old house in Palms, and I finally found a contractor that's gonna start looking at my house.
That's awesome. Well, welcome to town and welcome to rehabbing real estate. This is a cool time of year to do it. So that'll be fun, right? All right, so let's talk about the compensation agreement. So the first thing that happened in the big changes is they took Form 120, which was originally one form, and it was the compensation agreement. And it got a little too complicated because there were 2 ways you could fill this out. You could fill it out from the the seller paying the buyer's agent's compensation, or you could fill it out with the listing broker paying the buyer's agent's compensation, buyer's broker's compensation. Anytime I say agent today, I mean broker. Let's just go ahead and get that out of the way so I don't keep correcting myself. It's always between brokers. You guys are designated to sign for the broker on all of our contracts, by the way. And when that asks and they say, can you sign for your broker? The answer is yes. There are no forms that you can't. That being said, do not make that be the hill you die on. There are some brokers out there that absolutely want to make sure that I sign it. Say, okay. Don't use your bandwidth saying, no, I can sign it. It is not, shoot it to me, DocuSign, we'll get it signed. But the original form basically allowed you to choose. And what was happening is people didn't understand that. And they were having both the listing brokerage and the seller sign it. We were one of them because our thought process was that made sure the seller saw it, right? If there was any changes on there. A couple people argued that may have made it avoidable contract because you can't have an agreement for two people to pay something, so they separated it. So that's why we are here today. There's your fun little history lesson. So the first one that we have is the compensation agreement, listing broker to buyer's broker. Again, we're only gonna go through the changes today, and then if we have time at the end, we'll go through any questions about the forms afterward. But we're gonna go through the main changes of the forms, because the form itself is the same form. Okay, so the main change on this one does come to terms, which is in paragraph 4. So in section 4, they changed this because what was happening is you would receive a compensation agreement from a buyer's agent that basically bound you to a time frame and wasn't necessarily clear whether or not they didn't have to pay you should you not ratify a contract. So there were a lot of listing brokers that were hesitant to sign this ahead of time. So the purpose of this is they had attorneys review it and they've added this. This offer of compensation made in section 5 is binding on the parties to this agreement only. So it couldn't say you come back to with another buyer and be bound to it. If the seller and the buyer named in the section 3 are under an executed and ratified contract within 30 days of this agreement being signed. So what this means is you sign, I give this to Kylie as the listing agent, we all ratify it as long as my buyer on here and her seller on here ratify a contract within 30 days, and this is a binding agreement, okay? If the seller and the buyer named in section 3 or 4 are not under a signed agreement within the 30 days of this agreement's effective date, then this agreement is considered null and void. So again, you're not obligated to be this for any period of time, more than 30 days of the execution of this agreement. Everyone understands so far? Pretty easy peasy.
You have to re-sign if 30 days passes.
Technically, you'd have to re-sign if that's a good point, if it becomes a long negotiation, or if you come back to the contract, right? You ever had that happen? Buyer and seller don't agree. They all say, well, to heck with you, we'll go somewhere else, and then they come back together, right? If that's outside of the 30 days, you would need to have a new one signed. Okay, then the last part of section 4 that is important, that the seller and the listing agent are gonna wanna see is payment will only be made at closing unless otherwise agreed upon in writing. So this reiterates what is already said in the listing agreement, what is already said in the buyer's agency agreement, which is that payment of commission unless otherwise agreed upon is not paid until there is a closing on the property. Alan?
Question,
Yes.
backup contracts normally take a few weeks to ratify if it happens. Then what happens with this? You have to sign it again once it's ratified?
Well, a backup contract is actually a ratified contract with backup terms. So as long as you've come to an agreement as a backup contract, it would be protected in this.
Okay.
Great question. Great question. Okay. Any other questions on this part? Again, they're not big changes. Like all of these though, the communication between us, meaning the agent bodies, is where this gets messed up. So don't be hesitant to ask a question, because we all want the same thing here. All right, the next part that changed goes down to section 5, and basically what they did is they cleaned this up and just made this a little bit more specific of how it was paid. There was a lot of different options and everything there. It's basically going to be an exact dollar amount, it's going to be a percentage, or it's going to be other, not really sure what other would be. So I would go ahead and tell you, it's not an official policy, but don't
Bitcoin.
use other.
Bitcoin.
What, Bitcoin, right? That's a good point. It could be, yeah, it could be anything else. I'm gonna go ahead and say, don't use other without consulting me or someone within Calius first. I don't really know what it would be. It's gonna be a flat fee or it's gonna be a percentage.
Would
That's
that be
it.
where you put a bonus?
You could,
Like if it was a percentage plus a bonus?
you could, but a bonus would drop probably with a buyer's agent, with a builder would be, they wouldn't be using this anyway.
What if it's not a builder?
Then it would be included in here. But like if it's a 1% bonus, then you would do 3%
Or
plus
if it's like
1.4%.
we are advertising like $1,000 bonus if you're under contract with.
Then
a
you
certain
would-
period.
You check you couldn't do exactly, then that would be the other.
Okay.
There you go.
There you go.
Takes a village. Takes a village.
3% plus.
3% plus, you know.
Have 3%.
You could write, right, you
You'll
could
say
put, we can
addi-
say that in here, by the way.
additional
We're under the same
percent.
broker in charge. It's okay to charge 3%. We can say that as a brokerage under one broker. It is okay to actually talk about it. We couldn't say that if, say, somebody from Carolina One was in here and say, let's all charge it, right? That's the big difference we have. So 3% is a good example that you can use on anything. All right. The next part. This is a little bit more of a disclaimer that says if the listing, again, this one is between the listing brokerage and the buyer's brokerage. So what this says is that the listing broker defaults by failing to pay the buyer's brokerage compensation at closing, or defaults by preventing closing in violation of the contract of sale, listing broker must pay the buyer's broker compensation. to me, it's just saying the contract's enforceable. Right, it's just reiterating that the listing broker could be held liable if they say, I'm just not going to pay it, or if they cause the closing not to happen. Okay? Question on that? All right, last part is they just specify in here if there is an issue between the two parties of this contract. Who are the two parties of this contract?
To brokers.
The two brokers, right? This is another problem with the first one, is you can't bind the general public to dispute resolute in a certain way. Right? You have to, you can only do that with people that are members of the association, which you all are. So by doing so, what you're agreeing to say is if we get into any sort of dispute resolution, then we agree to arbitrate before we start suing everyone. That's really what that says. Questions about that? Okay, last part, miscellaneous clauses, is basically saying, here's some miscellaneous things you need to know. That's the same as it was before. Questions about this?
I have the footnote. What is that?
Brokers commission are not set up.
No?
That one
further-
there.
No, at the very bottom.
Very bottom.
There's a blank. See the blank?
Does the agent have to sign that if you're implementing a for this copyright?
Form is copyrighted, may be only used, blah, 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 blah.
In which blank is involved as a real estate licensee.
Let me see if that's because this was an early form.
And has it gone into effect yet?
Yes, went in effect on Tuesday. Let me get clarification on that. It's likely going to be,
Just for zip forms, we don't.
it's gonna be, so. Here's the thing that we miss a lot. If you're not a member of the association, you cannot use this form.
Right,
So it's probably reiterating that for a couple of different ways, because I know there's a whole entire different discussion about being a member of the association. The association owns this form. They copyrighted the state association. It is one of the main reasons that we are with them, not the only, it's a main one. So that's probably a disclaimer on that. I will get clarification on
right,
it.
but do we have to fill out something?
No.
there?
You don't have to fill out something in the bottom. Because you're still having, the legality of the form use does not negate the bindingness of having two parties sign an actual document. If that bindingness is an official word, right? Does that make sense? So I'll get back to you on that as a follow-up on what that is. This wasn't something I gave us on. All right, any more questions on that? Just the changes? Okay, next one, same form, different parties. This is going to be between the seller and the buyer's broker. They're the only changes that are different on this one from the other one. We talked about the terms, that was on there. We talked about how it was being paid, that was on the other one before. The only difference on this one is at the bottom, two things on here. First one is seller acknowledges the compensation paid to buyer's broker is for services the buyer's broker provided to the buyer. It is again a full disclosure. I've got it highlighted up here. So it is a full it's basically disclosing that even though the seller is paying for it, the buyer's broker is only providing services for the buyer. It is just an additional disclosure to make sure you don't have a seller come back and say, well, wait, I didn't realize I was paying this for Delisha to represent the buyer and not represent me. Okay, it's just an additional disclosure that's on there. This here, the second disclosure down here, buyer's broker certifies that they have informed their buyers of the possibility of being paid by more than one party and has obtained a buyer's written permission to do so. Two things on this. Number one, all this is saying is that you as the buyer's agent have filled out properly either the transaction brokerage agreement or your buyer agency agreement, because that does disclose both. It does say that you could be paid by both. They have to agree to it, but it does say that you can be paid by multiple parties. That's all this is doing is, once again, it's telling the seller that the buyer's agent has explained to the buyer that they are getting paid here and they could be getting paid from somewhere else. What's somewhere else? It could be a myriad of different ways. It could be from their buyers directly. It could be in very few instances, but it could be from the listing agent as well as the seller, and you're asking the seller to kick in more. We probably won't really ever see that, right? Or it could be, like I said, from the buyer. Those are really the two other ways. Yes.
So you say we don't see that often, but like, would that be a circumstance where, because I've done this a lot,
where the buyer's agent is offering 2.5, and I'm like, well, I get paid 3.
The sellers, the listing agent's offering 2.5.
Yep,
Okay.
and then so the seller kicks that in as the concession or whatever.
The concession is, well, so concession is different, so that could be the other area. The concession is actually the buyer paying it out of their concession.
Okay, say that again.
So, no, a concession that is covering commission is the buyer paying the commission out of the concession they got from the seller.
And that's on the purchase agreement.
That's on the purchase agreement, separate from the compensation agreement.
Okay,
But if you could probably possibly use both these forms.
You could,
So if the listing agent is offering X,
correct.
but you want more.
When you want more, if the listing, so when, but again, this one, and this is, I do have a question to SCR as to why the same disclaimer is not on the other one. There's really no reason it shouldn't be on the other one. It does create a little bit of confusion. But it's basically the multiple ways that it can be done are this way, from the buyer directly, from the listing, or from the listing agent. Those are really the only ways that it can be paid to the buyer's agent.
Can I ask what the office's like recommended? Not policy, but like which form is best to use? Like,
What's the situation?
like the listing, like as the listing agent, is it better that we do the listing broker to buyer's broker or the seller's to buyer's?
It depends on what the sellers agreed to pay in the listing agreement.
Right, but if we're coaching them on
Best case,
like
I
what
mean,
is cleanest,
cleanest
yeah,
is listing brokerage to buyer's broker.
right, okay.
Okay,
So same as how we probably for the most.
Or as normal.
yeah,
Right,
yeah.
so, but there, correct me if I'm wrong, there are some brokerages that are essentially doing just this, the seller to buyers.
Yeah, there are some brokerages out there,
And
EXP,
that's why
Boulevard, a
this is-
couple of them are not allowed, they're not paying listing commissions from their brokerage.
So they're
Let
having
me-
their seller pay it.
Correct, let me
separately.
clarify. They are not saying that a seller shouldn't pay it. This is a very, like, they got vilified wrongfully.
Yes,
Let me be clear, like, there's nothing wrong with what EXP or Boulevard did. I personally don't think it needed to be done. They're doing it to remove some liability, and that's fine. That's their choice. I have utmost respect for John Liberatos. He's a brilliant broker. He just decided to do that to protect any liability for them being in the brokerage business as it relates to the monies. That's fine, but they're not saying they're advising their sellers on the market and probably saying, hey, it's a good idea to pay the buyer's agent because they're likely gonna ask, okay, I'm not speaking directly for them, but that's,
yeah.
yeah, to
So
clarify
that's
on that.
where that came from.
Correct.
Okay, I just wanted to know where we stood.
Listen, the entire purpose of this was to make sure the consumer understands their options. I fully believe in optionality, and I also fully believe in making sure you communicate with the consumer the best option in your professional opinion. And our professional opinion, my professional opinion, which I would encourage it to be yours, would be that you have a commission paid to the listing brokerage, so that is set. And the listing brokerage pays a portion of that to the buying brokerage. That keeps the commissions over here in one area, and then when you negotiate over here with the buyer, you keep that in that area. If you start saying what the seller's paying and paying out of concessions, it all is the
Messy.
same, and we get that, it just in my opinion, makes it messy.
Yep.
Heidi, and then I'll come in.
Just to clarify, on this form, the 3 options for paying the commission, it
Mhm.
looks like they forgot the percent on the second one, because it was on the other, but it is a percent.
It is a percent. They'll update those.
Yeah,
They
and
they
it does
clearly
have the
proofread
same
it before.
typo.
Yeah.
Okay.
Yes.
Practicality wise,
Mhm.
when we go to the closing table
Mm-hmm,
and we look at the CD
mm-hmm.
and it's got the.
Let me say one thing really quickly, and I'm not picking on Nancy, but Nancy brought this up, and it's going to be in the next broker minute. For those of you that are not looking at the settlement statement until you get to closing, with the utmost respect, shame on you. We have had 2 in the last 5 days where the commission was wrong and no one saw it until after closing. Don't judge, these were good agents, y'all are busy, I get it, but put your gavels down, Judge Judy's, like, it happens, but.
Well, it's
Read
fair
this-
to the attorneys.
And I get that, right, I get that, if that's where it shows up, so that's just my quick little soapbox, I'm back, Nancy, your question. Practical.
It's our job to make sure our seller or our buyer, whoever we're representing is right, so whatever, anyway.
Kind of.
The commission's Well, yeah,
Yeah,
you know, if there's a credit, you need to make sure your buyer's credit's on there anyway.
Yep.
But in practicality, you know, when you look at the settlement statement and it says the debit from the seller side.
Mhm.
And you have two commissions coming from, how is this going? It'll look the same, I assume, whether the seller is paying it, because the seller's paying it regardless. If it's coming from the seller, the title, the closer is gonna write two checks and they'll both come from the seller's side anyway.
so can we park that and come back to it? Cause I know what your question is, and there is some clarification needs to be on there, but I'll make sure I cover everything. Cause at the end of the day, it does net out the same. Right, but there is a difference on there. Okay. Next, last part of this. If the seller defaults by failing to pay the buyer's brokerage commission at closing or defaults by preventing closing in violation of the contract of sale, seller must pay the buyer's brokerage commission compensation. All this is saying is, once again, if you default as seller and you don't close, then that overrides, property doesn't get paid. This is basically unless otherwise agreed in writing. This is one of the otherwise agreed in writings, meaning if you default on the contract, you would still be liable to pay my commission. Okay? 9 times out of 10, it's a hard battle to win right there. But just again, there's a lot going on right now. I'm very consumer focused. I please don't misunderstand what I'm about to say. The customer is not always right though. Okay, let's just go ahead and get that out there. And we're seeing a lot of that when it comes to these agreements. We are seeing customers or clients a lot of times that are like, hey, I'm gonna move on and go buy with someone else, or I'm gonna do these sort of things. This is a bilateral binding contract. And I don't want you to avoid pointing a lot of these out, because when you don't, and then that happens, then the conversation comes along and says, well, nobody said that to me. Right? Anybody ever had that? Okay, well, you will, right? I mean, we see it all the time. And so this is why it's important to go to this. Basically, Mr. Seller, what this says is that in the event you do default on the contract, you still could be liable for the commission.
Yeah.
Which, by the way, that's your job to share that with them. If they start to say, well, you know what, they can have the earnest money, or they can do this. So this is why you don't want to be a lawyer, but you also want to say there are areas where you could be more liable. Make sense? Okay, any additional questions on this one?
On the bottom of both of these, your name does go at the very bottom. It will auto populate if you're in zip forms or if you're using Document, whatever. It will auto populate, but if you scroll down or at the bottom, I know that was a question.
Yeah.
Your name is.
Yeah, but if you have it both ways, is it gonna have, whose name is it gonna, whoever initiates it?
Yes, this will be.
So if it's between
whoever-
listing and buyer's
Resident
broker,
funds.
whoever
It's-
initiates. it.
Yes,
Okay.
correct.
You'd like putting my name in that space.
Your name will be there. Trust me. Zip forms automatically does it. They automatically
Yeah.
put your name there. If you're gonna fill it out, please write your name out. You can do it dynamically if you need to, but your name goes there. That is how the association verifies and validates that you are a member, that is authorized.
Ah, right, that makes sense. It used to be also on the side, but not in a specific phrase.
Yeah,
Right,
correct.
Yeah,
okay.
perfect, thank you. All right, next one. Form 130, fire agency agreement. Y'all having fun yet? All right, 3 of you, cool. All right. Here we go, a couple changes on this one. First one is the length of the agreement. They made a couple changes here. Number one is they did not set a start time. They basically said that the start time of the agreement is when when you execute the contract. Makes sense, I mean, I guess, I don't know. So just keep in mind that that's when it starts. So if someone doesn't sign it or date it, you may have some confusion there, make sure you do so. And then it runs to whatever date you put on here. What has changed is the bold area, which says that this, agreement can only be terminated before the date if both broker and buyer sign a release from this agreement, Form 255, there is no unilateral right to terminate by either party. This goes back to what I was saying earlier. Keep in mind that 95% of the form changes come by the Forms Committee reviewing and the SCR reviewing what the legal hotline has seen over the last 3 to 6 months. And this was a big one. I've got 3 on my desk right now where buyers have just said, I'm going with someone else. Right? And so this is, again, a reiteration to say, this is a binding agreement. So again, you need to explain that to them. Not to, again, some of you get a little weird, don't get weird, it's an agreement. Like, if you professionally presented this, it's not like you're locking the door and saying, don't leave till you sign. It is just informing them that what they have is a binding agreement. Make sense? Questions on that? All right, next change. Page 2 of 3. Brokerage fee, they've cleaned this up, made this a little bit simpler. Again, you've got your percentage, an exact amount, or other. Okay, this is definitely clean. This next part's gonna be fun. Gonna be very interested to see how this works out. Bonuses. So basically, this is where you would put in what a bonus would be if you were getting it.
You don't know.
Where?
Okay, so this is where
Page 3.
practicality, page 2, where practicality and actually business practice are conflicting a little bit. Okay, so I am a member of SCR. I fully support SCR. I don't always agree with SCR's legal advice, or I should say I agree with their legal advice. I don't necessarily always agree with their protocol advice on this. So in their video, they have said that you don't fill this out until you know what bonus that you're getting. That is not practically possible if you've got buyers that are looking at new construction as well as resale. Okay, hold on one second. So my advice to you on this one is based on your knowledge of the market and what possible bonuses will be paid. You put the best case scenario bonus in here. Just like, by the way, you should be putting best case scenario commission here. We are seeing this a lot. We are seeing this a lot where, for example, purposes only, if you put 2.5 and you actually show a listing that's offering 3, we've had occasions where buyers will actually say, I don't want to amend this. I want that additional 0.5%. I'm willing to bet without a shadow of a doubt, had you put 3% at the beginning, the buyer would have been fine with it. Okay, the other challenge that this is being shared from SCR, and I've asked for actually the statute or the legal part of this, is they state in there that you cannot change or raise your commission without showing that you are going to change or raise your level of care. I don't know that that's written anywhere. I think that might be SCR opinion. But again, that would be taken care of if you would just put best case scenario here and best case scenario there. Now, I understand that your buyer may say, well, I appreciate, Stella, that you're doing that. But if they are only offering 2.5% and you're willing to take that, where do I get that in writing? And I do appreciate where that comes from. And we can toy with some verbiage on here. It doesn't say you can't do that in here, right? I'm toying with some verbiage to maybe throw in there that says in the event commission is less, all parties agree to take less. That's, I also don't want to tell you how to run your business from that standpoint, okay? Nancy? Okay,
Would it be advisable there, let's suppose for exercise purposes that we had a 3% agreement with the buyer, and we're showing a listing and putting an offer on a property that offers 2.5. Would you suggest that at the time of making the offer, we make that change in the buyer's agency agreement?
you can. If it's really only needed if your buyer prefers it. So I would present that to your buyer. I would say, Mr. and Mrs. Buyer, Delicia's listing is 2.5%. Okay, so in that case, I'm not gonna hold you to the additional 0.5%. We can amend the buyer's agency agreement if you want me to, or just know I'm not gonna hold you to it. Again, it's kind of talking out both sides of your mouth, and it's like, you wanna use your judgment a little bit on the negotiation bandwidth with your client. If you've got like a high detail attorney engineer, then you go to them and you just say what you want to do, because they're going to appreciate that first. If you've got, you're going to have to kind of use your judgment on that relationship.
You suggest waiting till if it gets ratified rather than doing it at the offer stage in case it doesn't get accepted?
So say,
Otherwise, you're gonna change it again.
yeah, say to them, say, once this is ratified, we can amend this.
Right.
You can, same thing applies. The
Right.
buyer may see that as a risk that you
Right.
wouldn't ratify.
Can I share what we've been doing?
Sure.
This is recommended for everybody. So we've actually been doing an addendum to our buyer agency agreement specific for the property.
Good idea.
Because then it doesn't change your agreement. So if you don't ratify, you're still bound, you know what I mean? It's just for the negotiations of this particular property.
How are you tying the addendum to the buyer agency agreement?
We're writing it in on the addendum.
But where on the buyer agency agreement does it refer the
You
addendum?
refer to it.
Put it in other,
We haven't done
Contingencies?
that.
So if you haven't, then you technically may not have a binding addendum. Cause they would have to sign off on the original agreement,
Yeah,
acknowledging the addendum. I love the practice. I mean,
Yeah.
conceptually, it sounds good.
yeah,
The challenge is if you, they're like, this goes away
uh-huh.
and you then all of a sudden you have an addendum over here that is
So you would
technically.
need to upload your assigned buyer agency agreement and then write in addendum.
You'd have to reference the addendum, which would then
To
at that,
technically amend that and then have the addendum.
which would essentially be changing your buyer agency agreement, which would then kind of negate what you
I
did.
know, but it's only for that particular property.
But your addendum wouldn't be binding.
You can't you put something like that in the contingencies?
You can.
So you can make, I mean, so if you have it as a form or whatever, you can, we would ask you first.
Mhm.
That's what,
Well,
you know, to make.
Who would ask an attorney? Who would ask an attorney? Or has had asked an attorney at some point in time? Be recorded.
We put in the top part, in the broker fee, and then we can say, so we can not have to approach our buyers afterwards.
Yeah.
And so we can say either way, so that's.
Right, so in the contingencies, you just amend it right here for the purposes of
And then you
particular
don't have another-
property.
You could, but then you'd have to amend it back. So regardless,
Well, if it's only for that property and they don't go under contract for that
True.
property, then it's null and void.
It's kind of like what we do with listing agreements, when if they sell it to their neighbor who they've already been talking to.
Yeah.
Kind of changes the scenario, right?
everything, here's the part that I don't, I get the purpose, but also understand anything in writing can be amended.
Yeah.
As long as everyone agrees
And signs.
and signs,
Okay.
right?
So
So,
if they end up buying new commission, a
Mhm.
new construction,
right,
and they're offering $10,000 to an agent.
right,
If you don't know your buyers so well, or if they might say, I don't want you to have it.
Correct.
So if we have something in here ahead of time. that says-
which you would cover on bonuses here.
Right, but if you don't know what it, if you're showing them new construction as well as resales,
Mhm.
and you don't know what it is, I wouldn't put something in as a bonus unless I knew there was a bonus. And as you said, going back to them afterwards, let's say they're looking at resales only.
Mhm.
And all of a sudden they're like, I don't want a toilet that somebody else has ever sat on.
Yeah.
Okay, let's go to new construction. You had them sign this, and all of a sudden here, boom, you're getting, so going back to them and saying, look, this, some of these are open, and they're like, well, I don't want you to have that money. I
Right.
agreed to this, I want the $10,000.
And that's their right.
So if we put it in the contingency.
Doesn't make, if you put it in the contingency, they still have to agree to it.
Right,
Putting it in the
that's it.
contingency is no different than putting it here.
Go up front to say, we are agreeing on you paying 3%. Or whatever, or, and you come out and whatever. So, and then you say, but if we find a property that you
Hold on.
ratify, that's 2.5%. Or, and on the other side, flip side, if we find something that offers the agent a bonus, buyer is okay with that.
That's what that is.
But that,
Can I ask?
Let me be very clear on this. When you start writing optionality into the contract,
Right.
you're practicing law and potentially making an unenforceable
well, that's why we're
contract.
asking you,
Right.
that's why we're having,
So use this.
but that's a specific number.
Correct,
Can I-
as would your contingency. You can't put open-ended. That is by law dictated.
Oh,
You
can't
cannot
say-
have open-ended. That was. Correct.
Build or offer a bonus.
Correct, you
Why-
cannot.
why-
You have to have a fee that is agreed upon by everyone. Shakima.
Cause I got this yesterday and I sent this out, so I wanna make sure, do I need to clean this up? I put 10%,
Fine.
and thinking if it's different, I would just come back.
Yeah, because you can always take less without having to
Okay.
amend.
Okay.
Okay.
Yeah,
You put 10%.
10 sounds great.
10% bonus, cause I don't know what a bonus is.
Right, right.
Yeah.
Yeah.
Now, and again, it doesn't necessarily, it doesn't bind them
Right.
like it would here. You
And
put
let's say the
10%
bonus
here.
goes being 2%, I would
Correct.
just come back.
Yep.
and- Okay.
Yep.
Joe, for that percentage, is that include everything, or is it just the bonus?
Just the.
Above a bonus, yeah, in addition to. It's just the bonus.
Okay, so if you have 3% up there and you can have 2% there, and
Yep,
that's.
it'd be 5 total. The buyer has given you permission to take that. Now, it doesn't say up to, and this is something that SCR is it doesn't say up to. But again, this doesn't bind them to pay the difference. So there's not a risk here. It is saying that you'll get paid a bonus of this. There's not a legal opinion yet to say if you put 3% and the bonus is 2%, then all of a sudden you have some avoidability of the contract. That I think we're too early to find out if there's like a legal opinion on that one. Right? The up to is only really makes a difference in the top part, because then your buyer could be, is liable for the difference should you hold them to it.
Yeah, I don't know who's in charge of the form, but it would have been nice if it was a up to. Right.
Right.
To.
It was at one point, and the reason behind removing it. A,
So that it's not.
there was, it was, I think it was,
It was more with the lawsuit and discretionary, so.
Yeah.
Which is why they've been saying, hey, you have to have a actual number, just like closing costs used to be a certain dollar amount or a percentage. Now we have to put a certain dollar amount, you have to be specific. That's,
Yeah.
it's all it's about.
I don't know, cause they do it in the listing agreement.
Yeah.
They say up to in the listing agreement when
Oh,
it
that
talks about
didn't
what you
change.
can offer, when you can offer the buyer side, so. It's, alright, yep.
So, but if I'm reading this right, you need to fill in both a percentage and a dollar amount.
No, we
No,
won't.
or the other.
Or it's a or.
It's an or.
Or,
Okay, but if a builder is offering a dollar amount, it falls
Then you
underneath
go-
that
you gotta
percentage,
change
like
it
is that?
anyway.
up
If it falls under the, yeah, I mean, again, you're going to a technicality, which I think that's,
why I'm at?
I understand. So, okay, so quick side note, these are forms written by humans too. So we're also,
no chat GPT?
there, yeah, so we're also gonna be dealing with things that will come up. Which is again, why if you put the percentage of 10%, there's nothing in here that says that you could take less, or that they're bound to do more. So if you did 10%, it ends up being the flat fee, in my opinion, and I'll verify legally, but in my opinion, for our brokerage, that is fine.
Okay.
You're
And it
covered
doesn't
by
have to be
that.
Amended because.
It wouldn't have to be amended because it's under the amount.
But their percent says of the gross purchase price.
Right,
Okay.
yeah. Yep. Okay,
I mean,
anything
you're
else?
talking About getting 10%.
Right, no, listen, um,
50 sounds better.
all right, next change, we're gonna jump down to the bottom of section 7, right above section 8, where it says other buyers. Says here protection period, it does add a protection period for you. That basically says if within blank days after expiration of this contract, the buyer purchases or leases any property the broker has shown him during the contract, buyer will pay with a brokerage fee stated in section 7 of the agreement. This will be interesting to see how this plays out, because any other in the termination that you have, it says this is void should they re-sign with someone else. This does not say that. I'll be curious to see how that goes.
Oh.
I think the purpose of it was to protect that situation. So you are protected in that. So if this expires, now, again, if you sign the conditional release specifically states that Stephen and I are agreeing to cancel, and there's a protection period, but it does specifically state in there that that protection period ends if they relist or if they re-sign with another agent or brokerage. This does not say that. So from a technical standpoint, this would protect you in that standpoint.
I bet there'll be a lot of grievances with procuring costs on that one.
100%. 100%.
If I'm remembering correctly, before, didn't we have to provide a list of property shown and within a certain period of time?
That was a best practice. There was never in a form that said, here's a list.
Okay.
So, I mean, it's not a terrible idea to have said list.
But it would be in showing time.
It would be in showing time. I mean, you'd have a record of it.
Yeah, I just, I
Yeah.
thought I
A
remembered
third
that.
party.
Correct. All of this goes, by the way, to choose your battles. And I'm not saying, listen, don't let my cynicism say, don't battle it. We'll battle it if it's needed, but also understand 9 times out of 10, there's going to be a resolution that's found prior than, you know, this escalating. But everything you have in your court to win that is best case scenario.
Okay, this, I don't know if this was before and I just didn't notice it, above that where it says direct seller listing broker to buyer broker compensation. Buyer does not authorize broker to request that the broker fee to be paid in whole or in part by the seller / listing broker to broker closing. Any such arrangement, this confused what,
It's the same thing that was said before. It's just saying, it's basically saying, it said that before. It says that it would actually put the perspective of it, the tense of it, if you're looking at it grammatically, was actually from the buyer's agent standpoint, which was saying, I will go and try to get all of my commission from it. This is just changing the tense of it, saying that the buyer will or will not allow you to do that.
I think my question was because it doesn't say listing broker, buyer broker, it just is. It does not authorize listing broker to request buyer's brokers, I mean, it just kind of is.
Well, it's a buyer's agency agreement, so it would only be referring to their buyer broker.
And then
Okay,
it goes
so this-
back,
It just assumes buyer broker.
then it goes back and says any amount paid by the selling / listing broker to its broker.
Right, it
So
just, to me, it just was kind of convoluted, it just didn't.
Yeah, I mean, it's just basically saying you authorize your broker to request that the broker fee be paid by either the listing broker or the seller. Does, yes.
What you check does not.
Right, that's why it confused.
Optionality.
If the buyer wants to hire you, wants to pay you a fee to represent them, and they don't want you to be paid by the seller,
Yeah.
Okay.
Yeah.
I've been doing this for a minute.
He has. All right.
or to.
Other buyers, they did add this one that basically is, once again, there's a form 140, that is encouraged to be used. It's not ever been a required form, but it's basically saying that there's a form where you understand that potential buyers have entered into a similar agreement with you as a buyer's agent. This was disclosed before, but this is basically stating it once again, that there's a form that could be filled out for this as well. It's just, again, over disclosure that you will be working with, potentially with other buyers that are looking at similar properties, and you're not gonna advocate for one over the other. Okay? Yes.
I think that's because you didn't go over the administrative fee section. I don't know if any of those technically changed.
They didn't. They may be formatted differently, yeah, but the verbiage on them is not.
Oh.
Yeah. All right, anything else on that one? Okay, this is gonna bring up some spicy conversations on this one. All right, here we go with form, where am I? 310.
No.
All right, Form 310, purchase and sale agreement. This is gonna rub some of the OGs the wrong way. Read through it. My mirror, read through it. All right, a couple different changes on here. First one is going to be in section 6, which is on the second half of page 2. Transaction costs. So a couple specifications that they were put in here. Some of them are just added verbiage, and then we got some changes, a little bit of it all. The first part, under buyer's transaction costs, it actually added in parentheses, buyer's compensation, which is the amount of compensation the buyer owes their broker. Okay, so that's what it is saying there, that the buyer's compensation, when it says it's part of the buyer transaction fees, it's saying the amount of compensation they owe their broker. Okay, so that is just, again, specifying for everyone, if in the part of the transaction costs for a buyer will include any commission that buyer owes their broker. Okay, it just said broker's compensation before. There was some confusion as to whether or not that meant buyer or seller, even though it was under buyer's closing costs. It's not, none of this was meant to include already agreed upon commission outside of that. This was what they would be paying out of their closing costs. Okay.
If there's a difference between 3 and 2.
Right. Or all of it, but yes, yep.
Get clarity on that too, because at one time, we were told that we couldn't use all of a concession towards.
We'll come back to that because that was told incorrectly,
Okay.
situationally specific. But we are going to cover that. Second part, section 6.2, same thing. On the seller's closing fee, it also says the amount of the compensation. The real estate broker compensation is the amount that the seller owes their broker. So again, that's gonna be clarified. I'm willing to bet in the near future, there's gonna be a small change made to this one that will also say, or buyer's broker, according to agreement outside of that, because they've now got an entire form that says seller to buyer's broker. That's speculation, but we'll see on that. All right, going down to the bottom. At closing. Right here. At, seller will pay buyer's cost not to exceed X amount, which includes non-allowable costs, blah, blah, blah. This amount should not include any funds that have been negotiated between the brokers or of the seller and the brokers and the buyer's broker in a separate compensation agreement. We saw this a lot more than some of you would believe. People were putting what was being paid from the compensation agreement, thinking this was the same thing in here. This does not have anything to do with what is agreed upon in the compensation agreement, the listing agreement, or the buyer agency agreement. This amount is simply what the seller is giving the buyer as concessions at closing. Nothing more. Nothing more. This was probably the area that got the most convoluted and the most confused in all of this. And it's really just that simple, which is, by the way, why I think our best practice should be commission is the agreement between the seller and the listing brokerage, and that the listing brokerage offers out commission here. Let the buyer and seller work out what they're paying each other.
So in the case that, let's say you have a 3% in the buyer's agent agreement, the listing agent is offering 2.5%, and we want to pursue that 0.5% through concessions, what is the guideline?
We'll go through it here. Basically, the guideline would be, in that case, you are gonna ask for a certain amount of concessions, and from those concessions, you can pay your commission. Okay? Here's where there was, going back to, I think, Shakima's question in option A. Is the buyer and the seller agree to allow up to X amount of buyer's transaction costs? Split over 2 pages, which is super fun. Go towards the buyer's agent commission, see number 1 above, which we talked about. Okay, so this is where they initial that it will be allowed. The concessions cannot, going to the next page, go solely to pay buyer brokerage compensation if the concession was advertised in the multiple listing service.
But that's not legal anymore.
Concession is.
Oh, concession.
So this is where it got really confusing before, so understand. Let me be very clear on this, how this is written. If there's no advertisement of concession in the MLS, you can use 100% of the concession to go towards agency fees. Before, we were trying to play the game and say $1, right? You know, or whatever, or the dollar difference, right? That's not what's necessary. The seller concessions being used towards buyer's agency agreement could not be 100% if it were advertised in the MLS, which honestly, that's really not happening that much. I mean, some are saying seller concessions are offered. Okay, that I guess technically would be it. But if they have not advertised seller concessions in the MLS, this doesn't matter. You don't have to give permission of a certain amount being used towards commission.
I thought it was a question in the email.
Say that again?
I thought it was a question in the email.
Yeah. It is.
It's yes or no.
It's yes or no.
It's yes or
Who's
no.
gonna police this?
So how does that?
Good question.
But yeah.
I mean, yeah, you could, but some are saying, no, they don't want it advertised. Some sellers are saying that. They don't want seller consent because they want it to be asked.
I recommend not advertising it.
Yeah, I mean, it's like, and I don't necessarily disagree with it because we all know, regardless of how adamant your seller is, they're gonna look at everything.
Right.
And you have to present everything. So in the situation where Alan just said, if the seller says, no, I don't want you to advertise concessions, 99% of the sellers who say that say, I don't want you to advertise this.
Bring me an offer.
I
But I'm
want them
open
to
to it.
ask for it.
Right.
Yeah.
Right.
Like, that's what they mean by that.
Okay.
So in that case, I mean, what you're doing though, is you could say, if by not advertising, they're going to just ask for concessions to cover for it. If you're not offering out at least whatever percent that you think is recommended. Does that make sense? Again, it does clarify it a little bit, but I think we got it. What I do like about this is it does take a little bit of the back and forth that was now involving the buyer and seller of like, well, wait, how does this affect my commission? Which, in my opinion, is bad, right? Because now all of a sudden you're making the contract about your commission.
So if it is advertised,
Then basically you could say that not 100%, basically saying the concession cannot go solely to that. Right? So you would say seller agrees to allow blank of the buyer. So it's advertised that they're giving concessions, okay? And they agree to give $10,000 in concessions, then you can have $9,999 going to commission.
back to the-
So we're back to that again.
A technicality.
Yep.
So what's best practice for listing agents in terms of the listing agreement and the advertising of compensation? What, have you worked out those best practices?
I don't know that there is one. I think it's, I mean, who in here's shown more than 5 buyers in the last 6 months? Raise your hand. It's a large portion of the room. Have any of those buyers say, I only want to see homes that are offering concessions? I don't think it matters.
They're not picking up on that.
They're not picking up on it. I honestly don't think it matters. I think I like Alan's technique of saying, let's go with no and have them ask. Because I don't think it shies away from it. I don't think buyers shy away from it. And quite frankly, I think it does kind of align you more with the seller.
Yeah.
Because you don't want a seller be like, hey, I appreciate you're asking 500,000, but let's make sure we're gonna tell them we're gonna take less. You just don't want them to hear that by saying, please offer concessions. I think the better practice is to say, Alan, I'm 100% with you on 500,000 and understand based on these stats, which we go through in the quarterly one, that there's a 52% chance they're going to ask for concessions and they're likely going to be X amount.
Yeah.
But let's see if they ask, because there's a 48% chance they won't.
So you
Yes.
prepare them for that scenario.
Yeah.
Right, but if, say, you as a listing agent are trying to help, cause all of your feedback is your buyers are going to new construction, new construction, new construction.
Mhm.
And we know the new construction is offering a concession, for instance, because we happen to get their emails to
Yeah.
say. And you want to mimic what builders are doing. And so you say you decide you wanna offer 5,000, 10,000, whatever in concessions. You're just saying that a buyer's, when they fill out this, the buyer's agent needs to know that they can't ask for all of it to be paid towards
I
them,
mean, they can ask all but $1.
all of it all.
Yeah. So, and again,
This sounds stupid.
yeah, it's, again.
We
it's-
actually see that?
Yeah.
Oh dear.
I've done it.
Yeah. Because again, the buyers may not need any extra closing costs. They may have, they may
Why
have
wouldn't they want them? They might not need it, but why wouldn't they want them? Why would you as a?
situationally specific. Yeah, that would be situationally specific. All right, any else on this one, on option A? Okay, again, not a big, just a couple small things in there, and then option B, they have on there that the seller can, by the way, say, no, I don't want any of this going to buyer's agent commission. They have that right. If they know they're offering out 3% or they're offering out 2.5%, some sellers would say, that's nice, I don't want the buyer's agent getting any more money from my contribution. The buyer themselves can pay as much as they agreed. But the seller can say, I don't want you using this money to go more towards the
That's
buyer's
the
agent.
lawsuit.
That's, yeah, and again, that's where a pretty arguable part of the lawsuit made sense, is you're requiring them to pay for fees that they aren't benefiting from.
Right.
So I understand where that's coming. All right, any other questions on that? Okay. Next part has nothing to do with commissions, thank God, section 8. Due diligence, so basically,
Hold on. Can we
Yes.
go through the HOA dues and assessments?
that's all the same. That has not changed.
Okay.
Yeah. So due diligence. Couple things on due diligence. Basically, they've rewritten this to reiterate once again that due diligence is for repairs and both inspections or excuse me, inspections, both from the buyer, from anyone they want, that happen during that are outside of any additional contingencies in the contract. So what was happening is you'd have a 10-day, 15-day due diligence, and you'd also have it contingent on appraisal, and you'd have it contingent on CO 100. The appraisal would get done, or the CO 100 would get done within due diligence, and it would come up, and the buyer would want an adjustment made, and the seller would say no, and the buyer would be like, I want to terminate, and the seller would say, well, it's within due diligence, so you owe the termination fee. Which is arguably a really silly argument, because if that were the case, just wait out the due diligence. But again, let's not do that. Basically, what this is saying is the first part, underlined due diligence period, the buyer may conduct any and all inspections they wish and may timely terminate for any reason or no reason at all. No reason at all. You need to circle that. It's always been in there, explaining it to your seller. Termination fee. Should the buyer terminate during the due diligence period for due diligence reasons, they will pay a termination fee of X. That hasn't changed. They've changed the formatting, but they really haven't changed the verbiage. Next one, this is a change. Should the buyer terminate under a different contractual contingency, financing, appraisal, CO 100, sale of buyer's property, et cetera, really leads it to any additional contingency, the termination fee will not be owed. The termination fee is only owed if the buyer terminates during the due diligence period for due diligence reasons. By the end of the due diligence period, they did add this, that you have one of these four options: accept the property as is, negotiate for repairs using Form 525. Parties agreed to other remedies via attorney drafted approval and verbiage from Form 390, which is a blank addendum, or terminate by delivering notice of SCR Form 313 and the termination fee, I'm seeing this a lot. And the termination fee. We're seeing this a lot right now where the buyer says, I don't feel I owe the termination fee because blank. I was told the fence was not encroaching. I was told this, I was told that. If I had done that, I understand the argument. But understand the fight for that is not in the contract. The fight for that is through legal recourse. So if a buyer wants to terminate and says, hey, Tony, I'm gonna terminate this because whatever reason I just gave, but I'm not paying $1,000 because had I known that, I never would have agreed to $1,000. Attorney's response is, my understanding of the contract is that by doing so, you would be in default. Or you wouldn't be in default, you'd be actually in as is. And then if you didn't move forward, you would be in default. So my advice is that you pay the termination fee per the contract, and should you feel that that was not due, then you can pursue that legally elsewhere.
Okay, so in the past,
Mhm.
when we had one that terminated, like if a party terminated, once you, when we talked about earnest and all that, once, and you both had to sign off on it, then we still considered it terminated, even though the earnest money hadn't been resolved. So this is, unless this is paid, your SOL, dude, you're still buying.
Yeah, that hasn't changed. Unless this is paid, you have not terminated.
Okay,
Still a binding contract. That's the challenge of having a unilateral option in here. There's a little bit too much for interpretation. Yes.
Do you foresee whoever makes these adding in a spot that it's required before, like, as part of the contract, that where that termination fee be sent?
It is.
It is.
It always has been. This is a good one. They've added some clarification on it, but the question is where should this be delivered? It should always have been delivered to where notice of delivery was on the last page. Like, that was always on there. So we just never filled it out because we're like, this isn't part of it.
Delivery, that's not an email?
That's also delivery of the termination fee. Yeah,
Okay, that wasn't clear, I guess.
I think the assumption was that because you're delivering the termination fee, that was the assumption, but they clarified it.
Okay.
They clarified it on there.
A lot of their.
We'll get to that.
They're still running around delivering these by hand with a check attached.
Which is one of the options, right?
But Venmo, they
Yeah.
act like that's the norm,
Right.
and that's a very rare exception nowadays. Even in the earnest money section, they still act like that.
Yeah, that's true. That's true. All right, a couple things and we'll get specified on that. Top of page, what page number am I on here? Right above section 9. So top of page 4, they've added on here basically that it says failure for buyer to do options 2, 3, and 4 above by the due diligence will result in an as-is contract in regards to repairs. Party agree that as-is means buyer buys the property for purchase price while seller maintains the property from the effective date through closing, subject to normal wear and tear. and sells the property for the purchase price unless otherwise agreed in writing by the parties in this contract. The otherwise agreed in writing would be your additional contingencies that are still out there. So it does not waive your CO 100, your appraisal, your home sale. On the top of page 4, right above section 9,
They brought that close.
bottom of 3, top of 4.
Divide it out again.
Yeah.
You understand?
Can they clean that up?
So the sections are.
I would hope so. We will see how the final one comes out. on
These
there.
are already in zip.
They're already in zip forms. They're already, I mean, they were out Tuesday, yeah. There probably will be some, I mean, they leave it open for like grammatical or clerical, ones on there. All right, one thing that was added to this is there's a buyer hold harmless that they've added to this one. It's actually in the buyer's agency agreement as well. This is buyers will hold harmless, pay damages and attorney's fees to seller and brokers for all claims, injuries, or damages out of exercise of these inspection rights. Seller will hold harmless, indemnify, pay damages and attorney's fees or brokers for all claims, injuries, and damages that arise out of exercise of the inspection rights. Brokers recommend that parties obtain all inspections as soon as possible. Brokers recommend that parties and inspectors use insurance to manage risk. Okay, so what that means, in its most simplistic form, is what was happening is buyers were coming back and saying, well, I've got all these fees now, even though I terminated, and I don't think I should have paid an inspection fee or all these. And so I think the agent should have done that. So this is an additional way to say, hey, this is on you, buyer. I will also tell you, your engineers and particularly your lawyers are going to push back on this paragraph. Okay, so when they do, shoot me an email, kind of review that situationally, but a lot of times they'll just want to strike it. Here's the deal, a hold harmless is kind of, I mean, if they're gonna sue you, they're gonna sue you. And I'm not trying to scare anybody, like we handle plenty of them. But if they push back, just say, let me check with my broker, fire an email to me, we'll get that figured out. Just know that it won't be uncommon. Don't let it freak you out if someone pushes back. Okay, because it says in here that they pay attorney's fees and everything. If I'm a buyer, if I'm a consumer, that's gonna intimidate me a little bit.
Yes. Mhm.
So, all right, technicality, section 17, the sex offender registry. This was just updated. The verbiage was to update to match the new statute that SLED released. There's nothing really in there, just in case anybody notices the difference. It was literally to mirror what SLED had updated in the law, in South Carolina law. All right. Last part, second to last part, biggest changes, couple things. Brokers' compensation, couple things they added here. This is the one where the OGs are gonna have fun with it. I'm in this paragraph here. Section 25. Party directs the closing attorney to use settlement funds to collect and distribute, or excuse me, disperse compensation to the broker in accordance with this agreement. Here's what they changed, or any separate listing or buyer agreement as amended between the party and a broker or affiliated licensees, also added. And document compensation, the note has been added. If the compensation of any broker is to be included in this agreement, the party should attach the buyer's broker compensation agreement, Form 120 or similar agreement, to this agreement to reflect the same. Basically, what this is saying, because a lot of the people we still have a lot of, and I was one of them, and now we're changing because the document has changed. Compensation between two parties that are not party to this agreement should not be in this agreement. They are saying now it can be referenced in this agreement with which, how everything is going needs to. Right, we have this a lot of times because you have the seller saying, well, I don't want to agree to the compensation until I know the offer. Well, great, you accept the offer and then the buyer now finds out they have to pay more in your commission because they're only agreeing to less in compensation. It just wasn't working. So what this is saying is that you can attach and reference compensation agreements to this. It is then, go ahead.
Can or should?
Can.
Okay.
I think you should in the event you don't have them agreed to ahead of time. If you have them agreed to ahead of time, it's kind of a moot point. Right? If you've got, because there's still a lot, like, I mean, honestly, 9 times out of 10, you show a Carolina One listing, here's your compensation agreement, right? 9 times out of 10, you show a Keller Williams listing, here's your compensation agreement, right? If you get the onesie twosies out there that don't, this is where you would include it as a reference on this.
In those other cases, none of this really matters, right?
In the other cases, it does matter because you'd want them in there in reference.
Oh, no, I mean, in like the normal case.
Correct.
They're taking the total commission and paying a portion to any agent to the property.
Correct. They're keeping the easy right, right? Yeah.
You definitely should go to your turn. nor the attorney, so that they know who's paying, where it's coming from and how much it is. And my mortgage guy also wants it because representing the buyer.
Yeah.
Wants to know if the buyer is paying anything as well. So
Yeah.
it's another, so it's
It's all part of the economy, people see it. That being said, we'll come back to that on your CD question as well. Section 26, this is what they changed to. They went ahead and added a list of optional or addendums or contingencies that can be put on here. This is an interesting move. I'll be curious to see how it plays out. Part of me likes it because it keeps it a little cleaner. The other part of me doesn't, because now everybody's gonna ask what all those are.
So should we attach the buyer's agency agreement?
I think you should if you are trying to show where they've agreed to more, like if they ask for it.
Right.
Again, if they've already agreed to the compensation agreement and they won't, then no. If they haven't and they're asking to review everything before they do it, I would say yes.
Because we had an attorney who didn't include the buyer's agency agreement in the compensation, because he said, oh, it's not attached to the contract.
That's interesting.
Yeah. Not so as well.
So, yeah, so in here, it gives you the list of the different forms, the compensation agreement, any addendums that you would have on here. This is a little bit cleaner of a way. It also does remind you if you're signing something, it does need to be referenced. Going back to Kylie's example with buyer agency, if you have an addendum that's signed and you don't have it referenced in the contract to which it's an addendum, you have a voidable addendum.
This is what new construction does.
Right, yeah. The only thing I highlighted on here, towards the bottom of that list, it says SCR Home Warranty Addendum Form 555. They haven't released it yet. It should have been released. I don't know where it is. But if you will notice, they've removed the entire paragraph about the home warranty in here. And I think that was just, how would you have that in there if you're not having it for every other affiliate that's out there?
Yeah.
Okay,
So you have to attach the home.
it's an addendum that you would attach if, again, it's also removed where you're not, because quite frankly, the disclosure of home warranties almost became a force of business practice. Like you're forcing someone to just always disclose, and that may not be what your business, some people just don't agree with home warranties. Right? Now, I'm not saying you shouldn't advise I think there's more of a risk to not tell your buyer about it. Because the buyer because here's what happens, they move into the house. 4 weeks later, the refrigerator breaks, they find out they could have had a home warranty, and you didn't tell them, even though we all know they're gonna come out there and put a Band-Aid on the refrigerator, right? It's still, the buyer's gonna be like, well, why did you tell me that was an option? So I don't, the jury's out on, we don't have that as a required document internally.
I do like the document checklist.
I like it, it keeps it a little bit cleaner. All right, Bottom of page-
Of a written list in the,
Right.
yeah. Yep. So bottom of page 6, top of page 7, this is where it says, both parties agree to provide an accurate notice address and email for all correspondence. The email and address of the brokers can serve as the notice address. It doesn't really kind of cover the frustration that Kylie was talking about as far as where you're delivering the termination fee.
That's on the seller now, isn't it?
The seller one has, where seller wants all contracts, correspondence, and terminations fee to be sent. Okay, there you go. So put that in there and addresses it on there. Now understand, whatever goes here, this is an important thing, whatever goes here and or here has to match where you're sending notices. So if Stella and I go under contract and I put my notice of delivery as the listing agent as joseph@kw.com. And Stella sends me a notice at my old, another email that may be saved, which would be our team one, Joseph at Saltmarsh Properties. I could argue she didn't send it to the correct place. So just make sure wherever you're sending your notices are matching what's in the contract.
Okay, so, sorry, because you know my questions.
Mhm.
Alright, so the address on this for the termination fee, I would put on the seller, right? Like, I'm not touching the termination fee, so I don't necessarily want my seller getting all correspondence.
No, I mean, you could put in here your email, here's what I would put your email and your office address.
Okay.
Yeah. Because that would be the best place for them to deliver it.
What if you're doing termination fee through Venmo or something?
You
like
put that in there.
So after agent's notification.
Yep.
Lower line or termination
Yes.
blank.
Yep. You would put that in there, cause that, I mean, we gotta get this, here's the deal, if you don't have either, you've got agents, I've got a handful of phone calls that agents are calling me frantically at 4:45, 5:00, 5:15. What office, where's your, freaking out. And here's the deal, if they slide it under the door in time, that counts. Like the goal here is not to trick them into not to, you know, I mean, they're making the effort there. Let's make it easier, right? And I think obviously an electronic one, and listen, here's the pushback. Well, what if they don't do that? Can we maybe verify that first? Like, I feel like we always go to the what ifs first. I think the majority, not all, of sellers will accept the termination fee electronically somehow. Okay, yes.
I was practicing real estate in Texas before I came here. We have an option instead of a due diligence, but it's the same thing, and if that fee gets delivered within 3 days of execution along with the earnest money, it's so much easier.
Yeah, it was a lot easier in North Carolina too, when we first reviewed this on the Forms Committee and pushed for it, and we opted not to do it. I mean, I get it. I think the fear was, the same thing. You've already released the money and the seller defaults on it, then you gotta go fight for the money. And the Forms Committee weighed out the risk and they felt that that was a bigger risk. Also, keep in mind, when this decision was made, we were seeing termination fees based on the market and negotiation in North Carolina, upwards of 10, 20, 30, some $40,000, basically fees to buy the house. I mean, and not on $1 million properties. I mean, there were parts in Raleigh and in places where it was nothing to write a $35,000 inspection or like a fee up front. Here it is. And sellers would absolutely do nothing. We had an incident, actually, a friend of mine who had the admin on his team terminate, that fee was so high. They actually turned and put an offer in on another house, knowing they could buy that house without this one closing because they had that fee. And oh, by the way, they had all the leverage and didn't have to fix anything. So that's one of the reasons that we were gun shy of doing it, was kind of seeing what our neighbors to the north are doing. In hindsight, it did not creep up here, which I think has worked in our favor a little bit.
Is there any conversation going on about establishing in section 8 due diligence? How to make the payment? Just establish it at contract instead
I
of
mean,
worrying about it later, or?
That's technically what this would be, is where the termination fee is being set. Yeah. That's where that would be addressed. Would it make more sense to be in section 8 itself? Probably. I mean, that's something we can run up the flagpole. All right. Nancy's question on this, on the CD, from a settlement statement, the commission should be reflected based on how it's paid. Right, so if you've got a standard situation where you've got 6%, 3% to listing brokers, 3% to buyer's broker, that's all going to be on the seller side. It's all a seller's cost. If you've got a different one where it's just for simplicity of it, they're not offering anything to the buyer's broker, the buyer has to pay it. It'll be 3% on the seller side, whatever concessions the seller have agreed, and then 3% on the buyer side because the buyer's paying the buyer's agent commission. So that's how that would be split up.
Saying, regardless of whether it comes from the seller, compensation agreements, brokerage, 120, whatever, both of that, it would look the same.
If it were coming from the seller or the buyer brokerage agreement, correct. Yep, yes. You're absolutely right. All right, what other questions do you have? Kathy?
But I see this a lot.
Okay.
You get an offer, it's perfect. You
Okay.
want to sign it with no changes in price or anything.
Mhm.
But the agent that sent it to you did not put any of the listing agent's info on the signatures.
Okay.
So I'm left to fill all of that in.
Mhm.
Did that technically counter? Because I have to fill it all in and
Yes.
that's.
Good question.
It is a good question. I would not fill it in at that point. I would sign it if you want to ratify the contract.
Oh.
Because I think you're risking it being,
On the other. Well, the listing agent or this buyer's, the listing agent does have to fill out.
Mm.
Like the client, are they represented as a client or a
Mhm.
customer? So there aren't things that the listing agent, when they get the agreement, the offer, they do have to add.
In the lot, in the agreement to purchase lots, they have to fill in seller states that
Yeah.
water is supplied by this.
Yeah.
So,
So if they don't initial off on that, then I would say you do have avoidable. Let me get back to you on that one. That's, I mean,
Stop the lot now,
Yeah.
tax map now, right?
Yeah.
Walker's paying their tax.
I wouldn't feel, yeah,
And
Yeah.
check boxes, they leave blank check boxes.
yeah.
My opinion, if it's blank, I'll fill it in.
Yeah, but it's a change and then the initials.
Well, it's not a change because they didn't choose one.
It could be a change though, if the options don't require, like, what would be an example?
May or may not deposit earnest monies in an interest bearing account.
Yeah, so I think on that one, you'd have a hard time on. Yeah, I'll do,
Conversation.
what?
Why not call and have a conversation?
You and your rational thinking.
Yeah, you can have a conversation, but you still have to amend
No,
it.
you still have to amend it, so I think that's the whole thing. I'll tell you what, I'm gonna pivot my broker minute for next week, so I was gonna report it this afternoon. If I can get the answers to these, I'll do that in the broker minute on Monday.
Okay.
If not, I'll send another one out next week on it. Yeah, cause
It's very common.
it is very common, and I would tend to say that if it fills in something, it shouldn't matter. But I also know that we've got a couple technicalities that have bitten us, and I just don't wanna put us in that. So let me get another opinion on that. Okay, what else? Couple more minutes, we'll take a break before team meeting, yes.
So if I have a buyer right now that I'm still waiting on, I just probably need to read through all the forms.
No, if you've already got them signed,
They're gonna see this is your initial.
okay, I'd go back. Yeah, I think if they haven't ratified it, I would just say, hey, good news is we got a better form. And because you've come to this riveting class, you'll be able to explain in a way that'll improve your value to the buyer more than ever.
If you already have buyers.
If you already have them yes, if you already have them signed, you don't have to go change a bunch of things on them.
Are
Okay.
these forms effective right now?
Yeah.
They're in zip form.
They're in zip forms. They're all, by the way, one of the easiest ways to see forms is that if you just need to reference them and get a blank one, the quickest way is through SCR. If you log into SCR, it's literally, this is what it looks like. It's got the entire list of forms in a drop-down menu. You just select one, submit, and it pulls up, and it will be the most updated one from SCR. Okay? Anything else? All right, you got 10 minutes until team meeting. Take a break. Thank y'all. If you have any questions, please let me know. I know this is a lot, especially if you're new. It wasn't supposed to cover everything, just the changes, so let us know.
If you're staying for TV, there's lunch in the kitchen. Do not dine and dash.
What's the team meeting?
What?
What are you gonna cover in the team meeting?
I don't know. Steven's doing it.
But I would do it.
Steven's covering it.
No.
Sorry.
You like my go cover in the back?
That's good.
A couple of minutes ago.